So Jones v. Bank of America is the second department. So that's the second level of that's the first. That's the middle level. It's not the Supreme Court. It's not the Court of Appeals. It's the middle level. It's the appellate division. Second department means it's Brooklyn or Long Island. It's 2012. So it's a predatory lending scheme case. And the homeowners brought suit alleging that the appraisers overvalued their property in order to enable homeowners to obtain a grossly, I want to skip. Let me just skip for 2 seconds. I'll go back to the predatory lending because that's a good one, but now we're on a tangent that I have to keep on. If you go to Rodin on page 18, which is not such a recent case, but Rodin for some reason gets cited all over the place, so I thought I should put it in here, and it fits in really nicely. In this case, the plaintiff loaned $50 million to Shore Mall Associates, a New Jersey shopping center, and the loan was expressly conditioned on the borrowers obtaining an appraisal showing that it had a value of at least $60 million. So this defendant appraiser came in at 65, which I don't know what the problem is, why he got sued. I can't tell from the case, but the plaintiff claimed that the appraisal was inflated and brought suit under contract, negligence, and fraud theories. So this is seeing the contract, negligence, and fraud causes of action all in operation in the same place. So, so the appellate division held that as professional appraisers, defendant owed a duty to plaintiff independent of any contractual obligation. And again, so that's why the guy in Kostrid, I probably shouldn't say this on tape, I have no idea who he was, but he probably was somebody's nephew or something, because the bottom line is, if you look at this first department 1999 case, I'm on page 19 at the top, the fact that you're a professional, the appellate division held that a professional appraiser owed a duty to plaintiff independent of contractual obligation. Professionals, common carriers, and bailees, for example, may be subject to tort liability, which again are general civil wrongs like negligence, for failure to exercise reasonable care irrespective of their contractual duties. In these instances, it is the policy, not the party's contract, that gives rise to the duty of care. So this case is a good one that explains the negligence piece of this. And look at what the court says under the court's holding and reasoning. The court concluded when a professional such as defendant has a specific awareness that a third party will rely on his or her opinion or advice, tort liability will ensue if the professional report or opinion is negligently or fraudulently prepared. So I said, what's this mean to appraisers? The same facts may be used to bring claims of contract and tort. The truth is really, I'm not sure why the plaintiff in Kostridge didn't look to the Rodin case and use that to, but even if he did, I don't think it would have worked because of that language that they put in there that said, don't get any ideas, this has nothing to do with you. It specifically excludes you. But then we get back to what Jay just said, which is, can you contract out of negligence? But the contract wasn't with the homeowner, so probably that language still would work. The point is there was the right result in Kostridge at the end of the day. But what I'm trying to get across is, from the lawyer's point of view, when you're prosecuting or defending these things, the same set of facts can give rise to several theories of liability, and like Jay said, that's what you're trying to protect against. But these are the different ways that it plays out against you in the courts. Now, do you have anything to say on that? Okay, so then I'm going to go back to the predatory lending case, Jones. What time is it? 5:50. Okay. All right, Jones v. Bank of America. It's Second Department, 2012, so it's the appellate court on Brooklyn and Long Island. And so a homeowner, this is a little bit new material now. The homeowner brought the suit alleging that the appraiser overvalued their property in order to enable the homeowners to obtain grossly unaffordable mortgage loans in order to purchase the property. And they sued them under General Business Law 349, which provides that, and now this is a whole other theory. This is, you've got your contract, you've got your torts like negligence and negligent misrepresentation and fraud, and now we've got general business law. That's a statute. So some statutes only allow the government to prosecute the appraiser, but general business law is a law that gives rise to the ability, I guess, of a private cause of action. So for anybody who commits deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service in this state, and there's a private right to recover. Okay, so, and they also alleged fraud in this case. And we already talked about what the elements of fraud are. So the court's holding a reasoning in this case is that the plaintiffs failed to allege that the appellant's alleged acts and practices misled them in any material way. So because the statute, General Business Law 349 for deceptive business practices, says that the alleged deception has to be material. Now, what is material? That, I think, is going to vary from case to case. But in this particular case, they found that whatever it was that the appraisers did or said in their appraisal, it wasn't material enough to rise to the level of General Business Law 349. And they also didn't find fraud in this case because, again, as I said, in general, it's a very hard standard to meet. So, so they won, not only at the, actually they lost. Wait, the appraisers moved to dismiss the complaint for failure to state a cause of action. The Supreme Court denied them, so they lost at the lower court in the Supreme Court, but the appellate division held for the appraisers when they took it up. So this case's takeaway, I put down, is that of all the other things you have to worry about, General Business Law 349, deceptive business practices, and fraud are not typically among them, but then we go to Flandera and Allstate where you did have to worry about fraud. But that pretty much covers the different types of causes of action. All right, this is something new. Predatory property flipping scheme. All right, so the homeowner brought an action against the appraisers alleging that the appraisers took part in a conspiracy to defraud her and other minority home buyers through a predatory property flipping scheme and provided appraisals that intentionally overstated the value of their homes. Plaintiff asserted claims in this case now that also were, the claims here were that they were violating federal statutes. Oh, I should mention, this is another federal case in the lowest rung of the federal court system. All right, so here, the reason they're in federal court is because they're alleging violations of these federal laws, like the Fair Housing Act, the Civil Rights Act, Truth in Lending Act, as well as city and state laws. So the appraisers moved to dismiss. Now, the appraisers defended themselves by saying, wait a minute, there's only a 2-year statute of limitations under these statutes. So statute of limitations, what's that? Everything you could possibly, you can't sue forever. Everything has what's known as every cause of action that we've discussed has a statute of limitations. It is written into the law how long you have to sue for different things. Breach of contract is 6 years. What's negligence? 3? 2?
3 years. 3 years.
3, depending on what it is. Okay, and these statutes, the Fair Housing Act, and the different statutes they were suing under, those statutes built into themselves 2-year statute of limitations. So the appraiser said it's more than 2 years since the injury or the alleged injury, so we're off the hook. But the opponents said that, well, and again, like I said, there's always the law and then there's the exception. The exception here is they said, no, this is the continuing violation exception, meaning where there are continuing violations that give rise to a claim of a discriminatory policy, the statute of limitations does not begin to run until the end of the last asserted occurrence of a discriminatory policy. So they tried to make it seem like this was an ongoing thing that went on for a long enough period of time that they would be within this 2-year statute of limitations. But here the court said no. They ended up saying, however, plaintiff does not allege a discriminatory practice that extends into the limitations period. Her complaint does not adequately allege actions on the part of any defendants after the closing, which in this case was 2005, but it didn't work its way up until 2012. So plaintiff does not allege any violations following her closing on 2005. So whenever they started this case that ended in 2012, they weren't within the 2 years. So that was the end of that. So what does this mean to appraisers? I think, and I think I did put this in the right order, because first we talked about all the different things you can get sued for: breach of contract, negligence, negligent misrepresentation, general business law, deceptive acts, federal regulations for fair housing. But all of these different things also come with different statutes of limitation. So sometimes when somebody comes into you and you're looking for something to sue somebody for, you're kind of playing with the theories, not only because they give you more leverage, but because breach of contract is 6 years, but negligence is 3. So the point is that your negligence cause of action might have gone away. Your Fair Housing Act cause of action will go away too. But then you might still have your breach of contract action. You have anything on that? You look like you wanted to say something.
I think what's interesting about this case is that it brings in the issue of a civil rights violation. And you can see housing discrimination cases in very different contexts, not only race, but sexual preference. You can see disability kinds of cases. And so if somebody is able to fashion a case, and I'm trying to think of how one would do it in an appraisal context. You know, I'm a little long in the tooth, and I remember, you know, in the early 60s, when real estate agents used to do blockbusting so that they could, vacate whole swaths of neighborhoods to turn it over on a race-based situation. They'd come in, they'd, sell, get somebody to sell. This was racial discrimination, where they would get a white homeowner to sell to a black family, and then the other white families on the block would be told that the blacks are coming, and then they would get them all to sell for much lower prices, and then the houses would be sold to black families, and then this was also that the real estate brokers could make commissions, and then, and turn over, a lot of houses. This was in the 60s. This is well documented. I'm sure appraisers at that time played a role in some of those sales. And what I'm saying is that discrimination can take many forms, and you can discriminate against different kinds of people. But if somebody can fashion a discrimination case against somebody, the penalties are exponential. You get into punitive damages, you get into attorney's fees, you get into emotional distress, you get into all kinds of situations that, I mean, I have a case right now in my office, and this doesn't have to do with appraisals, where a doorman, allegedly didn't give good services to somebody who was gay, allegedly because the doorman hated people who were gay. That's put him in a situation where his job may be at stake. The bottom line is, one shouldn't discriminate against anybody for any reason, because, and I don't know if it comes up in what you guys do, but if it does, avoid that because the liabilities can be extreme.
Well, it does come up in the sense that if you're appraising and it gets a Fair Housing Act claim.
Look, a Fair Housing Act.
Well, that was what this case is.
Right, yeah.
I had to do an appraisal for the Supreme Court on a matrimonial, and I specifically did not say that the house was in a strong Jewish community that had many synagogues. And I got castigated by the courts, and they threw my appraisal out because I did not say it was a heavy Jewish neighborhood.
Was that because if it was a heavy Jewish neighborhood, that would tend to elevate, at least for Jews? For people who are not Jewish, they might not want to listen, they may not want to live in an Orthodox community, let's say. But for a person, because in the Jewish community, it's important to live close to a synagogue, to a walking distance. So therefore, they might pay more for a house, 2 blocks from a synagogue.
But that's not the point he's making. He's damned if he does, and he's damned if he doesn't. Right?
Yeah, but I used the comparable sales from the community and didn't make any notation of a type of community. But
Matrimonial cases are a little crazy.
Oh my God, there's all these hands.
You mentioned the statutory dates.
Excuse me?
Statute of limitations.
Yeah.
What about the date of discovery? How does that play?
The date of what?
The date of discovery. Does that play or extend
In fraud, that plays a
So in other
role.
words, if the fraud allegedly happened in, let's say, 2000, but it was discovered in 2005,
I don't know if it works that way.
No,
With this.
with fraud, it's a question of when it's reasonably should have been
You're
discovered.
thinking about injury in toxic torts and personal injury cases. I don't know if that plays
So-
into this. I
so
don't
for-
know
for-
the answer.
I just don't, I don't.
So for
think-
instance-
I don't think there's a set of time limits.
There isn't.
There isn't.
For
Discovery plays a part in those time limits, correct?
Excuse me?
I don't know. The answer is I don't know, and you don't know either. I know you don't.
I know, I can tell you, I can tell you this. If somebody intentionally knows something, and let's say there's asbestos in the wall, and you know it, you cover it up. And so there's somebody going in and looking at the house can't see it, and can only see it if they open up the wall. That would be an undisclosed, it's not something that can be easily figured out. And so if 6 years later, there's a leak and you go in and somebody says, wait, you've got asbestos here, and then it can be shown that you knew it and you covered it up, that I would say the statute of limitations would not apply in that situation. That would be a rare situation.
But we're talking about, if you're talking about where does discovery of a violation of the Federal Housing Act, I just don't know. I mean, well, it's different than, it's different than a toxic tort. Oh, I didn't know I was sick, and I didn't know I was sick from this thing, and I didn't find it out until later. I don't know if it works. I didn't know I was discriminated against. I don't know if it works the same way. I just have to look it
I
up.
think we would all like to,
Okay.
we would be very happy to know that after 2 years, we don't have to worry, but that isn't the case.
Well, in this case, but you don't even need to get to where you're getting, because the pernicious exception that can hurt you is discrimination as part of an ongoing, continuing practice. So this wasn't about discovering it later. It was about the fact that they were saying that it was some kind of scheme that was continuing to go on. In this particular case, the appraiser just got lucky that the end was the closing, because nothing else happened after the closing. The closing was outside of the limitations. So that's bad enough. Wait, there was a question back here, and a question, okay, go ahead.
Well, it was along the lines of what this gentleman said about date of discovery, and I spoke to an E&O carrier who told me that date of discovery does start the statute of limitations. So then in effect, there is no statute because you don't know when the date of discovery.
But discovery for which cause of action? I mean, I'd have to know, you know what I'm saying? Like,
He told me any, it didn't matter.
you just have to look on a case-by-case basis and what the case law in that area says.
That wouldn't apply to negligence.
Yeah, that's what I'm saying. It couldn't.
for fraud, it could come into play. For let's say housing, let me see. For negligence is 3 years.
Even if it's discovered,
Well, give me an example of how somebody discovers you're negligent 3 years later.
easily.
Okay, go ahead.
Well, I mean, I take it an example.
Negligence would be like typically, I slip on a banana peel, I fall, I break my arm. I know when I've broken my arm, that I've broken my arm because of
Well,
negligence.
give it the appraisal example.
An appraisal example, the oil tank was buried.
But how is the appraiser supposed to know that? You're not hired to do a phase one.
Well, I'm just saying.
If you knew, let's say if you knew the owner, and the owner said, hey, come on down here. See this oil tank? I'm covering it up.
You were negligent.
I'm covering it up.
No, wait, let me, you were negligent in pointing out that the oil tank was buried.
Right.
The homeowner finds out 3 years from now, he's got a buried oil tank. I'm saying the data discovery moves forward 3 years, and the appraiser is liable.
I'm saying I honestly don't know. Date of discovery is a very narrow, in particular thing that, you're right, it drives a truck through a statute of limitations, and I don't think it's just willy-nilly used everywhere. Like I said, I'm very familiar with the fact that it's used in toxic torts, because you can't find out until later that you have some terrible disease. But I'm not sure you could just, that goes across the board. I know, listen, I speak a lot and people raise their hands and will say, but my lawyer told me, but I said that I was gonna start using this line. The truth is that your lawyer can tell you a lot of things. I don't know that they're right, I have to check it. So, I mean, you can all put up your hands and tell me that somebody told you something different, but that doesn't mean that what you think they told you, or even what you're sure they told you is correct. All I can say is that I don't know. But I will say that data discovery, extensions of statute of limitations is very serious stuff, and I don't think it's across the board for everything.
Let me just talk about that oil tank for a second. Okay, and when we're talking about fraud, there's this concept of reasonable reliance. Now, I do a lot of transactions, but I was recently having a conversation with a client. They were going to purchase a building in Manhattan. And I said, I wanted to put in a representation in the contract that there were no environmental issues that the owner was aware of, that the seller was aware of. They didn't want to sign that. So I said to my client, are you okay with this? I mean, because otherwise, there are a lot of people who are buying real estate. Like I know a client, I spoke to a client about this, and he says his client, his company will not buy a piece of property without doing a phase one environmental study. A phase one environmental study will show whether there was ever an oil tank on the premises. So if somebody buys a property, okay, and the appraiser doesn't mention that there was an oil tank on the premises, that's not the appraiser's job. Okay, so I would say
It is?
it's not. It's not. Unless you know. If you have reason to know, you would put it in.
I don't
But-
think they all agree with you.
I'm doing something right now.
Okay.
I'm trying to buy a house right now.
Right, okay.
I saw that there was a brand new oil tank in the basement, all right? There was no sign of any buried oil tank outside, but because there was a brand new oil tank in the basement, I raised the question, is there something outside buried underneath the ground? And the answer is yes.
But the question is, if you were in a professional capacity, called in to do an appraisal of this house, would you be under a duty to make that inquiry?
I think I would be.
Yes? Dominic says yes.
Absolutely.
Wait, he's had his hand up forever.
Any suspicion that they might be.
Yeah. Yeah, but then you've done your due diligence.
What if the oil tank has been decommissioned legally and there's documentation that it is legally decommissioned?
Well, if you're an appraiser and you have notice, you have reason to believe that there was an oil tank, then you ask the homeowner as part of your investigation, And then he
And
says,
document.
and then he says, I've decommissioned it. Here's the piece of paper. Here's the guy who decommissioned it. Here's his license. Here's his permit. Then you remark on it, and then it's not. Then it doesn't mean anything. But I would suggest that for a regular house closing, and maybe Dominic, if you're walking through the house, you're measuring, you're doing what an appraisal does. Appraisers ordinarily do. If there's no evidence of an oil tank, I don't know, do you think that you have a
He
duty
does.
to?
Well, okay. Depends on the situation. If you have oil, first of all, you need to be knowledgeable enough to determine whether you have oil heat or gas heat. If it's oil heat, you're certainly going to ask the homeowner, where is the oil tank? If he says, yeah, it's right next to the boiler room, well, you go and look at the oil tank and you,
What if it's new and you say, where's the old one?
yes. And if there is oil heat, it's probably a good idea when you're doing the outside inspection to look at the grounds around the property in the front and the back, see if there's any dead shrubbery, see if there's like brown grass where there should be green, and that's part of your due diligence.
Here's my question. Will you see, wait a second. Here's my question to Dominic. Here's my question to Dominic. Okay, we know if there's an oil tank, we know oil is dirty fuel. We know you see an oil tank, a question should pop up into your mind as to how the oil has been handled. Well, forget that. What happens, you walk in, there's a gas tank. There's a gas boiler. Now the question is, at some point, let's say it's a brownstone, at some point in the 1880s, it was coal or it was oil. Okay, so what is your obligation to determine when the oil went away, when the dirty fuel went away, when did the gas tank come in, et cetera, et cetera? That's what a phase one is supposed to do.
Yeah, we don't even ask. If
Right.
it's gas heat and there's no evidence of an oil tank,
And no evidence, yeah.
Wait, we gotta go down.
Put in an addendum, that's all.
Okay, an addendum.
You due diligence and you put it in an addendum.
And a big part of all these cases is you gotta document, well, we're gonna get to the Ramapo case that talks about documenting. Wait, one more comment on this
Okay,
one.
so if there was an underground oil tank, there is usually a meter near the boiler that will show, there'll be a line coming in and there'll be a meter which will tell you how full the tank was. That's a
And they leave it there when they take it
If
out.
I see that, the first thing I ask about is there an underground oil tank, whether I've seen one or not in the basement.
Let me
Because
ask you
know there
this,
was
when
one
you
at
get
one
the,
point.
how to do an appraisal training, do they teach you about the brown grass and the
No.
old?
Teach anything, absolutely.
well, my society does.
When you go to these classes.
No, like the
That's all they teach you. Practicality.
You would be confident to know that there was an end date.
it would be. But you know, it's like a lot of things. It would also be comforting to know that for the same set of facts, you couldn't get sued for the city general business law, federal housing laws, negligence for fraud and for negligent misrepresentation and for breach of contract. But it's all out there. Wait.
Quick question. Should I still stay as an LLC, or does it really matter at this point?
You know what? I don't know the answer, but I need to ask Dominic this because, like, myself as a lawyer, I'm a PLLC, and that protects me for things like paying my rent or whatever, because the PLLC made the contract with my landlord.
Well, actually, I'm an S corp.
But the point is as a lawyer, you can nothing's going to protect me from professional malpractice. There's no insulation. You're an individual on that level. What is it like for you guys? Same thing?
I can answer this. It's New York State issues a license to you as an individual. There's absolutely no protection
Yeah.
under corporation law.
Right.
The
I didn't think
protection,
there would.
period.
No
You can have
protection.
1,000 corporations, it does not insulate you because the.
It's you as an
license is
individual that's holding the
directly on
license.
individual.
Okay.
They will not accept licenses to a corporation for appraisals. They will for brokers, but not for appraisals.
Can you incorporate it under your own name?
The corporation holds no protection.
No, but it's the same. The point is the license is you.
Well, I am.
That's how it is for me,
But I am
and that's how it is.
This corporation.
No, you are you. You're not your corporation.
So it doesn't pay for me to pay.
Your corporation didn't get the license, you got the license. But wait. This is the Estrada case. I love this case. I have to do this case. It's on page 24. This one is going to really blow your mind compared to any other one that I've done. And it's interesting because it's a little case. Purchaser of a residential cooperative apartment brought action against the broker, the bank, the appraiser, everybody. The appraiser always gets sued, alleging, among other things, fraud and deceptive business practices, what we've been talking about, because there was deception over the square footage size of the apartment. That was their complaint. So, which is kind of funny, because if you look at the case on page 59, we're talking about the difference between 500 square feet and 550 square feet. It's ridiculous. It is, but I mean, here's what's funny. So this case, also, notice, it's in the appellate division. So there was a case, and then it got appealed. All right? Here's why the appraiser won. I love this case. Plaintiff could not have reasonably relied on the alleged misstatements about a cooperative apartment's square footage in deciding to purchase the apartment. The advertisements for the apartment by the broker described the apartment as 550 square feet and as approximately 500. The discrepancy in the square footage and the various advertisements should have alerted plaintiff to the possibility that the advertisements were not accurate with respect to the square footage, but mere sales puffery. Under these circumstances, plaintiff should have taken the opportunity to inspect. Moreover, this is what I love, with respect to the appraiser and the bank, plaintiff could not have relied on the appraiser's report inasmuch as he entered into a contract to purchase the apartment 4 months before the appraisal was conducted. So you don't see how crazy this case is? They sued the appraiser because they said, oh, because of your terrible appraisal, I entered into this contract. But there was no appraisal when he entered into the contract. That's how good. Now, even that was just the case, I think it was funny, and I might not even put it in, but it's an appellate case. The appellate division had to say that. So not only did somebody, some lawyer out there, think it was a good idea to sue an appraiser for an appraisal that hadn't happened yet, but then they appealed it when they lost. I don't even want to guess what it cost to defend the appraiser in this case, and how, I mean, I'm glad I put this at the end, almost at the end. It's hard to imagine anything more stupid. I don't even know what to say. He's suing, saying, I entered into this contract because the appraisal deceived me. The appraisal didn't happen until 4 months later. That's crazy. Okay, so I don't know what to say about that, but you know, I do have a takeaway that's practical on that. Some people will have insurance counsel, some people won't. If you're having regular counsel and you have to pay for them, you should be asking your lawyer about, am I protected by statutes of limitation? Am I protected by just the facts of the case? Like, common sense should come in.
Maybe the plaintiff in that case thought that if the appraiser had measured the apartment correctly, he would not have come in at the contract price. And in that case, the plaintiff would have been able to get out of the deal based on a mortgage contingency. Maybe that's what that was their argument.
Yeah, but that's not what the court is saying. The court is saying, he's saying, I relied upon what you said and it was wrong. And he's saying, you couldn't have relied on it when you went into contract because it didn't happen until 4 months later. He's not saying it was an appraisal contingent mortgage. So it's just crazy that an appellate court had to say that. I think it would say it was an appraisal contingent mortgage if it was. Okay, wait, this last case, well, it's second to last case, but it's going to be our last case. I love this case too. I had written all my materials, and then I did one quick sweep before I turned them over to Dominic, and I found this case. It's the Ramapo case. Supreme Court, Kings County, and it's like January or something, or the fall. It just popped up. And I'm like, what is this? So I call this the competing appraiser case. So this is a case where appraisers, there were two different appraisers who were expert witnesses in a case. And it's an important case, and I'll tell you why. And you probably will... There's probably a good deal of appraiser work in this area. Tell me if I'm wrong. So there was a foreclosure on a 4-family house. The bank was owed $1 million. So then the bank goes and sells the property at an auction. Now, Real Property Actions and Proceedings Law 1371-2 permits the bank, the mortgagee in a mortgage foreclosure, to recover a deficiency judgment. So they get the difference between the $1 million that they're owed and then what they sell it for at auction. But that's not all, because what if they said do an auction and for whatever reason that day it sells for $1? So does that mean that the mortgagor now has to pay $999,000? And the answer is no, because it's either the auction price at foreclosure or the fair market value of the property, whichever is higher. So obviously the legislature is trying to protect the former mortgagor who's defaulted against an auction where it's just a bad day and the price comes in too low. So whatever higher. So if the fair market value was $100,000, but it actually sold for $120,000, fine. So whatever higher than that difference between what the bank is left holding and whichever number is higher, that's the deficiency judgment. So if you're the former mortgagor, you want that fair market value to be high. So here's why this case was interesting too. Because when the property was bought in April of 2012, it was $255,000, and then it was flipped for $690,000 in June of 2013. So this big disparity raised an issue of fact as to the proper valuation at the time of the auction in 2010. Now I know in Brooklyn, 2010, 2012, 2013, value is a moving target, but still, it was such a disparity that, so there was an appraiser for the mortgagor, and there was an appraiser for the bank. And obviously the appraiser for the mortgagor wanted it to be appraised high, and the appraiser for the bank wanted it to be lower so there'd be a bigger difference and they'd owe more money. So it was a big case. So there were two appraisers, one for each side, testifying. And one of them is in this room, but shall remain nameless. And that one is, so I didn't want to embarrass the person, so I called them Mr. Winner Appraiser on page 25. When I said, I'm reading, and I just want to read you one last time what the court said. It is a matter of the due diligence Mr. Winner Appraiser displayed in describing how he came to his findings in comparison with the guesswork and estimates of Mr. Loser Appraiser, who's not in Columbia Society. Mr. Winner established that he did research on market trends and comparable sales. He also researched the property's building code violations and building permits. Further, in choosing his comparables, Mr. Winner used a more concentrated geographic area than that chosen by Mr. Loser, and he documented his efforts as regards his chosen comparables. He documented his efforts, this comes up a lot, by calling brokers and using records of the multiple listing service. Furthermore, Mr. Winner's conclusions concerning the condition of the property was in relative accord with another guy who testified. By contrast, Mr. Loser first relied upon purchaser's instructions that he was to presume the property was to be gutted. Then at his 2012 inspection, he visited the building in the midst of demolition and drew conclusions about the building's structure, even though he is not trained as an architect or an engineer or contractor, and did not know if the items being torn out of the building were still operable before they were removed. Additionally, Mr. Winner based the adjustments he made to the building's value on the basis of renovations using actual sworn-to cost estimates for the property in the building department records, as opposed to Mr. Loser's use of a formula presented without any foundation. In addition, Mr. Winner recognized that while the cost of renovations affects the value upwards, how much the renovations affect the value upon market conditions, and noted that not every cent spent on renovations is necessarily a cent of added value. Mr. Loser's testimony and report display no such understanding of this crucial fact. In fact, Mr. Loser admitted that he reduced the value of a comparable to account for presumed renovation costs without knowing himself whether the comparable he chose actually was renovated. So, I just thought this was a great case. Even if it wasn't somebody here who was Mr. Winner Appraiser, as soon as I saw this case, I'm like, wow, this is a perfect case to put in, because this is how to, it's kind of a guide to how to prepare a good litigation report, or I guess a good appraisal. Can I tell him who Mr. Winner Appraiser is? No?
It's up to Mr. Winner.
Anyway, but No, but honestly, I could not imagine a more laudatory case about how an appraiser did something. And I read it before I realized, I'm like, oh my God, it's you. That's funny. But, and I was going to send it to you before I realized it was you. It was the funniest thing, because I wasn't looking at the title. Anyway, and he didn't even know it was published. He was like, how did you know that? I'm like, it's public record now. So anyway. Are we done? Is it 6:30? What time is it? All right, let's talk about the very last thing. It's called bonus material, and this is not my shining moment, because I said this is a very good article and it's enclosed. And for 100 pages of photocopying, I didn't enclose the article. But what it is you can find it on the appraisalinstitute.org. It's the most recent article by their general counsel, and it talks to something you were saying earlier. So the general counsel writes a very good article, and I thought I should include it. So a guy with a small appraising business found himself a defendant in a serious professional case filed by the FDIC over an appraisal he never worked on and he never signed. So how can you get in trouble for an appraisal you never worked on and never signed? He had a guy in his office. So he let the guy work in his office on an informal arrangement, and he rented a desk, and the appraiser did services for him, like he did his billing. So when this guy who was renting a desk did work, he sent out bills to that guy's client, collected the money, and his rental for the desk and for these administrative billing services, and also he let the appraiser use his, he let the guy in his office use his technology, like his geodata. He let him use it, and I don't know if it's geodata, but the point is he let him use his online services, and he let him have a desk, and he did his billing. So the appraiser's name was associated with the guy, and the guy committed a terrible malpractice, and then the FDIC is coming against the appraiser. And the appraiser said, but it wasn't me. But it was him. And so it was him because the guy was working under his banner. So he went to his insurance company and he said, I need protection. And they said, but you only have a single appraiser policy. Your policy is only for us to protect you. It's not to protect the people who work for you. So it didn't cover him, and he had to get independent counsel, and it cost him a lot of money to settle it. And it was a good article. It's on appraisalinstitute.org. Their general counsel has a blog, and it's the most recent article, and I thought it was good. And that's it. So I'm going to look up, what am I going to look up? The discovery of torts and appraisals, and if that keeps the door open, and we'll put it on the website.
Excellent. Once again, Michelle and Jay ITKOWITZ, round of applause. Another terrific presentation. Thank you very much. Thank you. Thank you.